You expect me to believe you live here?
Yes, this is my house. My ID is in my back pocket.
Yeah? Funny how nobody around here knows you.
I just moved in this morning.
You don't just move in here, not without someone noticing.
My daughter is inside. She's
Then maybe you should have thought about that before trying.
At 11:47 a.m. on a Saturday morning in the gated community of Prescott Ridge, a white woman dialed 911 and reported a break-in in progress. She described the suspect as a black female, acting erratic, possibly armed, moving boxes out of a residence on Wyndham Lane. She used the phrase, "she doesn't belong here," twice during the call. Police arrived 7 minutes later with lights, sirens, and weapons drawn. The woman they surrounded on the front lawn was not a burglar. She was Judge Denise Ayanna Carter, newly appointed to the United States District Court for the Western District of North Carolina, confirmed by the Senate just 3 weeks earlier. She was carrying a box of her daughter's books. Her 10-year-old, Naomi, was watching from inside the house through the living room window. Within minutes, Denise was face down on her own freshly laid sod, wrists cuffed behind her back, a knee pressed into her spine, while her daughter screamed from behind the glass.
The 911 caller watched from her porch with her arms crossed. She never flinched. What none of them knew yet, not the caller, not the officers, not the HOA president who had quietly made this neighborhood her personal checkpoint, was that within 72 hours, federal investigators would be pulling phone records, body cam footage, and HOA emails. Careers would be destroyed, criminal charges would be filed, and the woman they had just put on the ground would be sitting on the federal bench, presiding over the very type of case they had just created. Prescott Ridge sat 6 miles outside Charlotte, North Carolina, behind a stone wall and a wrought iron gate that opened only with a resident code or a guard's approval. The home started at $1.2 million. The lawns were edged weekly by contracted crews who were let in through the service entrance and expected to leave by 4 p.m. There was a clubhouse, a private pool, and a quarterly newsletter that featured recipes, landscaping tips, and reminders about community standards. On paper, it was one of the most desirable neighborhoods in the region. In practice, it had never had a black homeowner. Not once in 26 years. That wasn't an accident. It was a culture. The Homeowners Association, led by its long-serving president Karen Langford, 58, a retired real estate broker with a firm smile and a tighter grip on the neighborhood than any board member before her, had spent years building an invisible fence far more effective than the iron one at the entrance. Under her leadership, police had been called to Prescott Ridge 14 times in the past 3 years for suspicious individuals. Every single one involved a person of color. A black landscaper was questioned for 25 minutes while his white employer watched from her porch without saying a word. A Latino delivery driver was followed by a resident in an SUV from the gate to his stop and back again. A black real estate agent showing a listing to a qualified buyer was held at the gate for 40 minutes while Karen personally called the listing office to verify authorization. None of these incidents were ever formally reported. None were challenged. No one filed a complaint because no one in Prescott Ridge saw a problem. That was the neighborhood Judge Denise Ayanna Carter had just moved into, and it was the neighborhood that was about to learn what happens when the person you try to push out has the full weight of the federal government behind her. Denise Ayanna Carter was not born into the world that Prescott Ridge represented. She grew up in Sandtown, Winchester, one of Baltimore's poorest neighborhoods, in a 2-bedroom apartment with her mother Gloria and 2 younger siblings. Gloria worked double shifts as a hospital custodian and still couldn't always make rent. There were nights the power went out. There were weeks groceries ran thin. But Gloria Carter had one rule that never bent. You will study. You will read. You will become something they can't take from you. Denise listened. She graduated valedictorian from a public high school with a crumbling gymnasium and no AP courses. A full scholarship took her to Spelman College. Another took her to Howard University's School of Law, where she graduated top of her class. She clerked for a federal appellate judge on the 4th Circuit, then joined the Department of Justice as a civil rights prosecutor. For 12 years, she built cases against police departments that profiled, brutalized, and discriminated. She prosecuted officers who used badges as weapons. She sued housing authorities that redlined black families out of neighborhoods exactly like Prescott Ridge.
She knew the law. She knew the patterns. She knew how power worked when no one was watching. When the president nominated her to the federal bench, she became one of the youngest black women ever appointed to a U.S. district court. The Senate confirmed her, 58 to 42. She purchased the house on Wyndham Lane because she wanted her daughter, Naomi, to grow up somewhere safe, with good schools and open space. That Saturday morning, wearing jeans and a Howard University sweatshirt, she carried boxes from a moving truck into her new home. She had no idea her neighbor was already watching. Karen Langford had seen the moving truck pull onto Wyndham Lane at 9:15 a.m. She noticed it from her kitchen window while pouring her second cup of coffee. When a black woman stepped out of the cab and began unloading boxes, Karen set the cup down and didn't pick it up again. She watched for 20 minutes. She studied the woman's movements, the way she walked back and forth between the truck and the front door, the way she paused on the porch and looked around. To anyone else, it was a person moving into a new home. To Karen, it was a threat. She picked up her phone and called Linda Greaves, 2 houses down. Did you know someone was moving into the Wyndham house? Linda didn't. Karen called Paul Fenton across the street. Same answer. No one had heard. No one had been told. In Karen's mind, that absence of information was confirmation enough. She had told 3 different neighbors over the past month that she hoped the Wyndham property would go to the right kind of family. She never defined what that meant. She never had to. At 11:38 a.m., Karen dialed 911. The transcript would later be entered into federal evidence. There's a black woman at 4912 Wyndham Lane. She's going in and out of the house. I don't think she lives here. She's acting erratic, looking around like she's casing the place. I think she might be armed. I saw something in her waistband. She doesn't belong here. The object in Denise's waistband was a tape measure she had tucked there while measuring the front door frame for a new screen door. Karen used the phrase, "she doesn't belong here," twice during the call. The dispatcher classified it as a burglary in progress with a possibly armed suspect. 2 patrol units were sent, lights and sirens. Officer Wade Prescott was 43 years old with 18 years on the force and a personnel file thick enough to warrant its own drawer. 7 complaints of excessive force, 3 allegations of racially biased stops, all dismissed, all buried under internal review processes that treated civilian complaints like paperwork to be filed, not problems to be solved. Prescott had never been suspended, never been reprimanded in writing, never faced a single consequence for any of it. He had learned over nearly 2 decades that complaints disappeared and badges didn't. His partner that morning was Officer Danny Lucero, 29, 4 years on the job. Lucero was quiet, agreeable, and had never once questioned a senior officer's judgment on a call. He followed. That was his role, and he had never been given a reason to reconsider it. When the dispatch came through at 11:45 a.m., the call was coded as a burglary in progress, possibly armed suspect, residential neighborhood. Prescott pulled the cruiser out of a gas station lot and hit the lights. Lucero checked his sidearm. Neither officer ran the address through property records. Neither checked the county assessor database, which would have shown the home had been purchased 3 weeks earlier by Denise A. Carter. They didn't look at the mailbox when they arrived, which already bore her name in neat black letters. They pulled the cruiser directly onto the front lawn, tires cutting into fresh sod, and exited with weapons drawn. Denise was standing on the front porch holding a cardboard box labeled Naomi's Books in black marker. She looked up and saw 2 officers pointing service weapons at her chest. Behind her, through the living room window, her 10-year-old daughter Naomi stood frozen, watching her mother stare down the barrels of 2 guns. Prescott shouted first, "Drop it! Hands where I can see them! Get off the porch! Now!" Denise set the box down slowly, her hands rising to shoulder height, palms open and facing forward. She kept her voice even. "Officers, my name is Judge Denise Carter. This is my home. I just moved in today. I can show you my identification." Prescott didn't pause. "Sure you are. And I'm the mayor. Step off the porch and get on the ground. Now. Denise stayed calm. Sir, I am a federal judge with the United States District Court. My ID is in my back pocket. My daughter is inside. She's 10 years old. Please don't scare her. Prescott stepped closer, his weapon still raised. I'm not going to ask again. On the ground. Lucero circled to her left, positioning himself behind her, cutting off any path back toward the front door. Denise lowered herself to one knee slowly, still speaking. I'm complying. I'm not resisting. Please, my daughter is watching. Prescott holstered his weapon, grabbed her right wrist, twisted it behind her back, and drove her face first into the lawn. The impact was hard enough to press grass and dirt into the side of her face. He wrenched her other arm back and snapped the cuffs on while planting a knee between her shoulder blades. Inside the house, Naomi screamed. The sound cut through the morning air and reached every porch on the street. Neighbors stepped outside. At least 4 phones began recording. Karen Langford stood on her own porch 15 yards away, arms crossed, watching. She nodded once. Denise spoke into the grass. My daughter is inside, alone. She's 10. Please don't frighten her. Please. Prescott didn't respond. Lucero, without a warrant, without permission, without probable cause, walked to the front door, pushed it open, and entered the home with his weapon drawn. He found Naomi crouched behind the couch, sobbing, her arms wrapped around her knees. He shouted commands at her. Don't move. Where's anyone else? How many people are in this house? She was 10 years old. She could barely breathe through the crying. Lucero radioed in. Minor on the premises. No other suspects. He left her there, alone. He walked back outside to stand over Denise, while Naomi's cries echoed through the open front door for every camera and every neighbor to hear. Naomi Carter had been coloring at the kitchen table when the moving truck arrived that morning. She had helped carry 2 small boxes from the truck to her new bedroom, the one with the big window that looked out onto the backyard. Her mother had promised they would hang curtains together that afternoon. Purple ones. Naomi had picked them out herself. When the sirens hit the street, Naomi moved to the living room window. She saw the police car pull onto the grass. She saw 2 officers get out with their guns pointed at her mother. She didn't understand. Her mother was just standing on the porch holding a box. The box with Naomi's name on it. The one with her books inside. She pressed her hands against the glass. Her breath fogged the window. She couldn't move. She watched Prescott grab her mother's arm and twist it. She watched her mother go down face first into the lawn. She watched a knee press into her mother's back. That was when Naomi screamed. It was the kind of scream that doesn't stop on its own, the kind that comes from a place deeper than fear. Neighbors heard it from their porches. Cell phone recordings captured it clearly, a child's voice breaking over and over, calling for her mother. Then the front door burst open. Lucero came through it with his weapon drawn, even though the door had been unlocked the entire time. He swept the room. He found Naomi behind the couch, curled into herself, arms around her knees, face wet with tears. He pointed his weapon in her direction before lowering it. Don't move. How many people are in this house? She couldn't answer. She was gasping between sobs. Mommy, I want my mommy, please. Lucero didn't kneel, didn't soften his voice, didn't explain why he was there or that her mother was okay. He keyed his radio. Minor on premises. No other suspects found. Then he turned and walked back outside, pulling the door shut behind him. Naomi stayed behind the couch for 15 minutes, alone, in a house she had lived in for less than 3 hours. She could hear voices outside, but not her mother's. She didn't know if her mother was hurt. She didn't know if her mother was coming back. The neighbor videos captured what the body cameras missed, the sound of a child crying through an open window, calling for a mother who was face down in handcuffs 12 feet away and not allowed to answer. Gerald Forsyth had moved to Prescott Ridge 8 years earlier after retiring from a 40-year career in civil litigation. He was 72, white-haired, and had spent most of his adult life in courtrooms. He knew what lawful procedure looked like, and he knew what he was watching from his porch was not it. He had introduced himself to Denise that morning when the moving truck arrived. They had talked for a few minutes. She mentioned she was a judge. He had helped carry a box to the porch. When the officers arrived and put her on the ground, Forsyth didn't hesitate. He walked across the lawn, steady and deliberate, and stopped 6 feet from where Prescott stood over Denise. "Officers, you are making a serious mistake." Prescott barely looked at him. "Sir, step back. This is a police matter." Forsyth didn't move. "This woman is the homeowner. Her name is on the mailbox. Her deed is inside. I have her identification right here." He held up Denise's wallet and a manila folder with the closing documents she had asked him to grab from the kitchen counter. Prescott glanced at the wallet, then back at Forsyth. "We'll handle verification. Step back." Forsyth's voice hardened. "I've known this woman for 2 hours, and I already pulled up her Senate confirmation on my phone." He held the screen up, showing a news article with Denise's photograph in the headline. "She was confirmed by the United States Senate 3 weeks ago. You are handcuffing a sitting federal judge on her own property." Prescott's jaw went slack for half a second. His eyes moved from the phone screen to Denise's face, still pressed against the grass. The photo matched. The name matched. Lucero, standing behind them, went pale. His hand dropped from his belt. For the first time since they had pulled onto the lawn, neither officer moved. Neither spoke. Forsyth lowered the phone. "I suggest you uncuff her immediately and call your supervisor before this gets worse than it already is." Prescott did not uncuff her. He did not apologize. He did not check her ID. Instead, he reached for his radio and keyed the mic. "Dispatch, this is Unit 14. I need a sergeant at 4912 Wyndham Lane. Possible misidentification. Requesting guidance." Denise lay still in the grass, wrists locked behind her back, listening to the man who had just slammed her to the ground ask someone else what to do next. Sergeant Rita Bowman pulled up to 4912 Wyndham Lane 6 minutes after Prescott's radio call. She was 48, a 22-year veteran of the department, and the kind of supervisor who didn't need to raise her voice to make a room go quiet. She stepped out of her cruiser, scanned the scene, and understood immediately that something had gone very wrong. A black woman in handcuffs on a freshly sodded lawn, a moving truck in the driveway, neighbors with phones out, a child's muffled crying from inside the house. Gerald Forsyth met her halfway across the lawn, holding the wallet and the deed folder. He handed her both without a word. Bowman looked at the driver's license first, then the deed, then the news article still open on Forsyth's phone. She looked at Denise on the ground and back at Prescott. "Uncuff her, now." Prescott hesitated. "Sarge, the call said she was possibly armed." "I said uncuff her." Prescott removed the handcuffs. Denise sat up slowly, rubbing the red grooves pressed into her wrists, grass and dirt still on the side of her face. Bowman crouched in front of her. "Ma'am, I'm Sergeant Rita Bowman. I'm sorry, are you hurt?" "My daughter," Denise said. "She's inside, alone. She's been alone this whole time." Bowman stood, walked to the front door, and went inside. She found Naomi still behind the couch, knees pulled to her chest, face swollen from crying. Bowman sat on the floor beside her. "Your mom is okay. She's right outside. She's coming in to get you, I promise." She stayed with Naomi until Denise walked through the door 2 minutes later. Then Bowman went back outside and turned on Prescott. "What probable cause did you have? He got a burglary call. Did you verify ownership before drawing weapons? Did you check the mailbox? The moving truck has her name on the invoice taped to the door." Prescott said nothing. Bowman pulled both officers' radios and body cameras. She called the precinct captain from the driveway. The captain called the chief. The chief called the city attorney. Within the hour, the Charlotte FBI field office received a formal notification. An assault on a sitting federal judge is a federal crime. And when the DOJ Civil Rights Division opened a file that afternoon, the name on the intake form was familiar to half the office. Denise had worked there for 12 years. Federal investigators pulled the 911 recording within 24 hours. They played it back 4 times in a conference room at the Charlotte FBI field office. Every word was transcribed, time-stamped, and entered into evidence. There's a black woman at 4912 Wyndham Lane. She's going in and out of the house. I don't think she lives here. She's acting erratic, looking around like she's casing the place. I think she might be armed. I saw something in her waistband. She doesn't belong here. Each claim was checked against the facts. Erratic behavior. Denise had been walking boxes from a moving truck to her front door in a straight line for over an hour. Possibly armed. The object in her waistband was a tape measure, visible in both body camera footage and neighbor recordings. Casing the place. She had been measuring her own door frame. She doesn't belong here. She said it twice. Investigators then pulled Karen Langford's history with the department. What they found was not a concerned citizen making a one-time mistake. It was a pattern. 14 calls to police in 3 years. Every single one about a non-white person in the neighborhood. A black landscaper working a scheduled job. A Latino FedEx driver making a delivery. A biracial couple touring a house for sale. All unfounded. All logged. All ignored. Then the HOA email surfaced. Karen had used her position as president to coordinate what investigators would later describe as a neighborhood surveillance network targeting people of color. One email to the board read plainly, "We need to protect the character of this community before it changes." Another instructed residents to report anyone who doesn't look like they live here and let the police sort it out. Federal prosecutors determined that Karen's 911 call was not a misunderstanding. It was a fabrication. A false police report designed to provoke an armed response against an unarmed black woman on her own property. Given the documented pattern of racial targeting, the U.S. Attorney's Office added a federal hate crime charge under 18 U.S.C. Section 249. Karen Langford was arrested on a Tuesday morning, walked out of the same gated entrance she had guarded so carefully, and placed in the back of a federal vehicle. Her HOA presidency was stripped that same week by an emergency board vote. Within a month, her husband filed for divorce, citing in the petition irreconcilable differences rooted in moral disagreement. Karen's attorney released a statement calling the charges an overreach. The 911 recording said otherwise. Internal Affairs opened its investigation before the sun set on Saturday. The body camera footage from both officers was pulled, time-stamped, and logged into the department's evidence system by 4 p.m. A secure copy was sent to the FBI field office by 5. The footage from Prescott's camera began in the cruiser. He and Lucero were driving to the call, lights on, sirens wailing. Prescott glanced at Lucero and grinned. "Bet you $20 it's a crackhead." Lucero laughed. The camera caught it all. The audio was clean. The timestamp was clear. When they arrived, the footage showed Prescott pulling onto the lawn without pausing at the mailbox. It showed him exiting with his weapon drawn before assessing the scene. It showed Denise standing calmly on the porch holding a cardboard box. It captured her voice, steady and clear. "Officers, my name is Judge Denise Carter. This is my home." And it captured Prescott's response. "Sure you are. And I'm the mayor." The footage continued through the takedown, Denise lowering herself voluntarily, Prescott grabbing her wrist, the twist, the shove. Her face hitting the grass, his knee on her back, her voice underneath him. "My daughter is inside. She's 10. Please don't scare her." At no point did Prescott attempt to verify her identity. At no point did he run the address. At no point did he check the deed, the mailbox, or the moving invoice taped to the front door with her full name on it. Lucero's footage confirmed the unlawful entry. No warrant, no exigent circumstances beyond his own assumption. A weapon drawn inside a home where the only occupant was a 10-year-old girl behind a couch? Internal Affairs completed its preliminary findings within 5 days. Prescott was terminated for excessive force, racial bias, failure to follow verification procedures, and conduct unbecoming an officer. His 7 prior complaints were formally reopened. Lucero was terminated for failure to intervene, unlawful entry without a warrant, and traumatizing a minor during an unjustified search. The State Law Enforcement Certification Board opened emergency decertification proceedings against both officers within the week. Neither would ever carry a badge again. Federal prosecutors convened a grand jury to weigh criminal charges: assault on a federal official, deprivation of civil rights under color of law, conspiracy. The evidence was already in hand. Their own cameras had provided it. The neighbor videos hit the internet by Saturday evening. By Sunday morning, they had been viewed over 2 million times. The image that spread fastest was a still frame pulled from Gerald Forsyth's phone. It showed Denise Carter face down on her own lawn, wrists cuffed behind her back, a white officer's knee between her shoulder blades, while a cardboard box labeled Naomi's Books lay on its side 2 feet away. The caption someone added before sharing read simply, "She's a federal judge. This is her house." That image became the front page of 4 national newspapers by Monday. Cable news ran the story on every cycle. The phrase, "She doesn't belong here," trended for 3 consecutive days. Charlotte erupted. Protests formed outside the police precinct within 48 hours. Not riots, not chaos. Organized groups of citizens holding signs and standing in silence. Teachers, attorneys, doctors, parents with their children. They didn't chant. They held printed screenshots of the body camera footage and the 911 transcript. That silence was louder than any slogan. The mayor held a press conference Monday afternoon. He called the incident deeply troubling and promised a full and transparent review. Civil rights organizations rejected the language immediately. Deeply troubling was what politicians said when they wanted to sound concerned without committing to action. They demanded structural reform, independent oversight, a complete audit of every police call made to Prescott Ridge in the past decade. Investigative reporters delivered that audit before the city could. They pulled public records and discovered that Prescott Ridge had generated 47 police calls about suspicious people of color in 5 years. Every single one was unfounded. Not a single arrest, not a single crime confirmed. 47 calls. 47 people stopped, questioned, followed, or confronted for the crime of being non-white in a wealthy neighborhood. The police chief was asked during a live interview whether he had been aware of the pattern. He hesitated for 4 seconds before answering. That pause was clipped and reshared more than the interview itself. By Wednesday, 3 city council members had publicly called for his resignation. The city attorney's office began preparing for a lawsuit it knew was coming and knew it could not win. The evidence was already public. The body cameras had made sure of that. Judge Denise Ayanna Carter recused herself from any proceeding connected to the incident before filing the lawsuit. She would not sit in judgment of her own case. She would let the system she had spent her career building do its work. Her attorneys filed the complaint in the United States District Court for the Western District of North Carolina on a Thursday morning. The defendant list was long. The City of Charlotte. The Charlotte-Mecklenburg Police Department. Officer Wade Prescott. Officer Danny Lucero. Karen Langford. The Prescott Ridge Homeowners Association. The allegations filled 64 pages. Unlawful arrest, excessive force, racial profiling, Fourth Amendment violations, assault on a federal official, unlawful entry of a private residence without a warrant, intentional infliction of emotional distress on a minor, conspiracy to deprive civil rights under 42 U.S.C. Section 1983, failure to train, supervise, and discipline officers with documented histories of misconduct. The section on Naomi ran 11 pages. Her therapist, Dr. Renee Whitmore, submitted a sworn declaration describing the damage. Naomi had developed recurring nightmares in which officers broke down her door. She refused to be in any room alone. She flinched at sirens. She asked her mother every morning before school whether police would come to their house again. Doctor. Whitmore described it as acute trauma consistent with a child who had been made to believe her parent was being taken from her by force. She was 10 years old. The lawsuit also included a class action component. 47 people of color had been wrongfully targeted by police calls originating from Prescott Ridge over the past 5 years. Each had been stopped, questioned, detained, or forced to leave based on nothing but their appearance. Their names were added to the complaint. Their experiences were documented. They were no longer isolated incidents. They were a pattern. Discovery broke the case open further. Internal police emails showed that supervisors had been aware of the volume of calls from Prescott Ridge for years. One captain had written to a lieutenant 18 months earlier. "We're getting a lot of calls from that gated community. Same type every time. Unfounded." The lieutenant's response was 3 words: respond and document. No investigation was opened. No pattern analysis was conducted. No one asked why every single call involved a person of color. The city's legal team reviewed the body camera footage, the 911 recording, the emails, the class action filings, and the therapist's declaration. Their recommendation to the city council was unanimous and immediate. Settle. Do not take this to trial. You will not win. The settlement was reached 5 months after the lawsuit was filed. The Carter family received $1.8 million in damages. The 47 class action plaintiffs shared an additional $600,000 compensation fund, with individual amounts determined by the severity of each incident. But the money was not the center of the agreement. The mandated reforms were. The city agreed to establish an independent civilian oversight board with full investigative authority over police misconduct complaints. Mandatory verification protocols were implemented for all property-related calls, requiring officers to confirm ownership records, check identification, and make visual assessments before any use of force. Quarterly demographic audits of all police interactions would be conducted and published publicly. The entire department would undergo retraining in implicit bias, de-escalation, and constitutional rights. Body camera compliance would be enforced with a zero-tolerance policy. Any officer who failed to activate their camera during a citizen interaction would face immediate suspension. The criminal cases moved on a parallel track. A federal grand jury indicted Wade Prescott on 2 counts: deprivation of rights under color of law, 18 U.S.C. Section 242, and assault on a federal official. The body camera footage was the prosecution's primary exhibit. His own voice, his own hands, his own knee. The jury deliberated for less than a day, guilty on both counts. The judge sentenced Prescott to 4 years in federal prison. She noted in her remarks that his record of prior complaints demonstrated a pattern the department had chosen to ignore, and that this failure had culminated in the assault of a sitting federal judge on her own property in front of her child. Danny Lucero was convicted of deprivation of rights and unlawful entry. He received 18 months. His attorney argued he had simply followed a senior officer's lead. The judge was unmoved. Following orders is not a defense when the orders are unconstitutional. Karen Langford pleaded guilty to filing a false police report and 1 count of a federal hate crime under 18 U.S.C. Section 249. Her 911 call, her history of targeting, and the HOA emails left no room for a viable defense. She was sentenced to 2 years in federal prison. She became the first person in North Carolina convicted under federal hate crime statutes for a weaponized 911 call. Legal analysts called it a landmark. The precedent was set. A phone call made with the intent to provoke an armed police response against a person based on their race was not a misunderstanding. It was a crime. 1 month after the settlement, Judge Denise Ayanna Carter walked into the Charles R. Jonas Federal Building in Charlotte, wearing her judicial robes for the first time. Naomi held her hand. A U.S. Marshal opened the door to her chambers. On her desk sat a drawing Naomi had made during therapy. 2 figures holding hands in front of a house with purple curtains. Denise placed it next to her nameplate and sat down. Her first case that week was a housing discrimination complaint. A black family alleged they had been systematically excluded from a rental property based on race. Denise ruled with a precision her colleagues described as measured but unmistakable. She never referenced her own experience from the bench. She didn't need to. Naomi was still seeing Dr. Whitmore twice a week. The nightmares came less often now. She had made a friend on the street, a girl named Lily, whose family had moved in after the case made national news. They rode bikes in the cul-de-sac where the cruiser had torn up the lawn. New sod covered the tire marks. Karen Langford's house sat empty, a for sale sign in the yard, curtains drawn, no offers. The HOA was dissolved and reformed under new bylaws prohibiting discriminatory reporting. A bronze plaque was installed at the neighborhood entrance. This community welcomes all residents equally. Denise used part of the settlement to establish the Carter Justice Initiative, a nonprofit providing free legal representation to victims of racially motivated false police reports. In its first year, the foundation took on 23 cases across 3 states. She never spoke publicly about what happened on her lawn. When a reporter asked off the record how she felt, she said only this: "I didn't need them to believe I was a judge. I needed them to treat me like a citizen." That should have been enough. They tried to tell her she didn't belong. She belonged more than any of them knew. This case was brutal, but the case on the right spirals completely out of control.
I am a federal judge. You can confirm that
Save it.
immediately.
Credentials don't put you above investigation.
I am asking you to verify before escalating this.
You think because you've got a title and a big house in this neighborhood that nobody's gonna...
At 5:47 a.m. on Saturday, March 1st, 2026, 12 armed Homeland Security investigations agents in full tactical gear executed a no-knock raid on a quiet residential home in Silver Spring, Maryland. A flashbang grenade shattered the living room window before the front door had even been touched. Then came the battering ram. The door splintered inward on the first hit. Agents flooded the hallway, shouting commands, boots shaking the floor hard enough to knock framed photos off the walls. Barbara Okuosa Adeyemi was pulled from her bed in pajamas and thrown face first onto the hallway floor. Her wrists were zip-tied behind her back before she could finish a sentence. Down the hall, her 16-year-old daughter Rosaline was forced to the ground at gunpoint in her own bedroom. Bodycam footage would later show the girl's face, frozen in terror, a rifle barrel inches from her head. In the next room, 11-year-old Namdi stood paralyzed against his bookshelf, tears streaming down his face, a dark stain spreading down his pajama pants. Barbara's voice cut through the chaos, steady despite the pressure on her spine. "I'm a federal judge. I'm a sitting United States federal judge." The agent kneeling on her back didn't flinch. "Sure you are." Senior Agent Craig Loomis stood in the doorway of the bedroom, arms crossed, watching the scene unfold like a man observing routine work. He said nothing. He didn't need to. He had authorized every second of this. Craig Loomis was 46 years old, with 18 years in federal law enforcement and a career built almost entirely on post-9/11 fear. He had made his name running counterintelligence operations that targeted immigrant communities and black professionals with tenuous or outright fabricated links to foreign governments. 7 of his previous operations had collapsed before reaching trial due to lack of evidence. Not one of those failures resulted in discipline. 2 former colleagues had filed internal complaints alleging Loomis manufactured evidence and pressured informants into giving false statements. Both complaints landed on the desk of Supervisory Special Agent Donna Kessler, his section chief. Both were dismissed. Kessler had co-signed nearly every major warrant Loomis had pursued over the past 6 years. Among his peers, Loomis was known for what supervisors politely called big swings, high-profile raids designed to generate press attention and justify budget lines, rather than produce convictions. He had been chasing a promotion to Assistant Special Agent in Charge for 2 years. He needed a headline case. And when Barbara Okuosa Adeyemi's name surfaced during a routine intelligence sweep, Loomis decided she was it. Judge Barbara Okuosa Adeyemi was born in Baltimore to Nigerian immigrant parents who had come to the United States with nothing but education and discipline. Her father taught biology at a community college. Her mother worked as a hospital administrator. Barbara earned her undergraduate degree from Spelman College, then her law degree from Harvard, where she graduated in the top 5% of her class. She clerked for a federal appellate judge on the Fourth Circuit, then spent 8 years as a prosecutor at the Department of Justice, specializing in national security cases, the very field Craig Loomis now worked in. 4 years ago, she was appointed to the federal bench for the U.S. District Court for the District of Columbia. Senate confirmed. Respected across the legal profession for her fairness, her sharp intellect, and her willingness to check government overreach in surveillance and civil liberties cases. She was one of only a handful of black women serving as federal district judges in the entire country. Her husband, Dr. Chukwuemeka Okwuosa Adeyemi, a cardiologist, had passed away 2 years earlier from pancreatic cancer. Since then, Barbara had been raising Rosaline and Nnamdi alone, balancing a demanding caseload with school pickups, Sunday church, and the quiet grief of a household that still had his reading glasses on the nightstand. She was deeply private, deeply principled, and deeply rooted in her community. She was also, in every measurable way, exactly the kind of person the system was supposed to protect. Instead, the system sent Craig Loomis. 3 months before the raid, Loomis flagged Barbara's name during a broad-sweep intelligence review of individuals with what the agency internally labeled connections to nations of concern. Her connection was this. Her late father, a biology professor who had died in 2016, had traveled to Tehran once in 1994 to attend an academic medical conference. That single trip, over 30 years ago, by a dead man, became the seed of the entire case. Loomis built an affidavit alleging that Barbara maintained undisclosed foreign contacts with Iranian intelligence assets. He cited wire transfers she had sent to elderly family members in Lagos as financial activity consistent with covert channels. He pointed to her professional travel to The Hague for a judicial conference, a trip organized by the U.S. State Department, and described it as indicative of clandestine meetings with foreign operatives. Every claim in the affidavit was either a deliberate distortion or an outright fabrication. No corroborating intelligence existed from the CIA, the NNSA, or the FBI. No other agency had flagged her name. No confidential informant had provided testimony. Loomis submitted the warrant application to Magistrate Judge Howard Pruitt, a 61-year-old jurist with a reputation for moving fast through his docket. Pruitt signed the warrant after a 9-minute review. He asked 0 questions. He requested no supporting documentation beyond the affidavit itself. And with that signature, 12 armed agents were authorized to break down the door of a sitting federal judge and drag her from her bed in front of her children. For 3 hours and 14 minutes, agents moved through every room of Barbara Okwuosa Adeyemi's home, with the efficiency of men who believed they were untouchable. Bodycam footage from multiple agents would later document what they seized. Laptops from the home office, cell phones from the kitchen counter and both children's bedrooms, family photo albums pulled from a living room shelf, Barbara's judicial case files, binders and folders containing active federal proceedings, carried out in open boxes without covers or seals, her children's tablets, financial records from a filing cabinet in the hallway, her late husband's medical files, still kept in a drawer beside his side of the bed, and a box of personal letters her father had written to her mother from Nigeria over the course of 40 years, the same letters Loomis had described in his affidavit as coded communications. Barbara sat zip-tied in a kitchen chair the entire time, still in pajamas, watching agents dismantle her home around her. She asked 4 times to call her attorney. Each time she was told the request would be processed later. She asked 3 times for her children to be brought to her, denied without explanation. Down the hall, Rosalind sat in her parents' bedroom with an agent by the door, sobbing, asking over and over if her mother was being arrested. No one answered her. In his own room, Nnamdi sat on the floor with his back against the bed, guarded by an armed agent in tactical gear, clutching a stuffed bear his father had given him. He did not speak. He did not move. Loomis personally entered Barbara's home office and began reading through her judicial case files. When a younger agent standing nearby asked quietly whether they should be handling court documents, Loomis did not hesitate. "She's not a judge today. She's a suspect." 3 minutes after the first flashbang shattered Barbara's living room window, Bill Tavares was standing on his porch across the street in a bathrobe and slippers, phone raised, recording. Tavares was 68 years old, a retired firefighter with 30 years of service and the kind of instinct that told him when something was deeply wrong. He had seen the tactical vehicles pull onto the block at 5:44 a.m. He had watched a dozen agents in helmets and body armor pour out and stack up along the front of the house. And when the grenade went off and the door came down, he pressed record. Over the next 2 hours, his phone captured everything visible from the street. Agents moving in and out carrying boxes, evidence bags clearly containing children's electronics, small tablets and laptops sealed in clear plastic. A moment, 53 minutes into the footage, where an agent walking toward a vehicle held up a framed family photograph and said something to a colleague that made both of them laugh. Tavares caught the moment Rosalind's face appeared briefly in a second-floor window, tears visible even at distance, before an agent pulled the curtain shut from inside. He walked toward the perimeter once and asked an agent what was happening. He was told to return to his residence immediately. He stepped back, but kept recording. He did not go inside. That evening, sitting in his kitchen with the footage still on his phone, Tavares told a reporter something he would repeat in every interview that followed. "I spent 30 years running into burning buildings. I've seen houses raided for drugs. I've seen bad situations. But I have never in my life seen anything like what they did to that woman and those kids. And I knew right then somebody needed to see this." At 9:15 a.m., 3 hours and 28 minutes after the first agent crossed her threshold, Barbara Okuwosa Adeyemi was finally permitted one phone call. She dialed Obiora Nwankwo, her attorney and one of her closest friends, a constitutional law specialist who had known her since their years together at Harvard. Bodycam footage from the agent standing nearest to the kitchen captured the call. Barbara's voice was controlled, measured, almost clinical, the voice of a woman trained to function under pressure. But the camera also captured what her voice did not betray. Tears running down both cheeks, her jaw tight, her zip-tied hands trembling against the kitchen table. "They broke into my house. They terrorized my children. They are calling me an Iranian spy. I need you here now." Nwankwo arrived in 40 minutes. He walked through the damaged front door in a suit, briefcase in hand, and identified himself immediately as counsel for Judge Okuwosa Adeyemi. Loomis, standing in the living room reviewing a stack of seized documents, barely looked up. Nwankwo stepped closer and spoke clearly enough for every body cam in the room to record it. "My client is a sitting United States federal district judge for the District of Columbia. You have seized active judicial case files from her home office. That is an unconstitutional violation of the separation of powers and judicial independence." The room went quiet. Agent Bryce Dillingham, standing near the hallway, looked at Loomis. 2 agents near the front door exchanged a glance. Loomis's expression did not change, but his hand stopped moving over the papers in front of him. "We'll verify that," he said. Nwankwo's response was immediate. "You should have verified it before you put a flashbang through her window." Loomis stepped into the backyard and called his section chief, Supervisory Special Agent Donna Kessler. He kept his voice low. Kessler ran the name through the Federal Judiciary Personnel Database. The confirmation came back in under 2 minutes. Barbara Okuwosa Adeyemi, confirmed sitting judge, United States District Court for the District of Columbia. Appointed by the President of the United States. Senate confirmed. Active caseload of over 60 pending federal cases. The ambient audio from a body cam still recording in the kitchen picked up Kessler's voice through the phone speaker, tight and clipped. "Craig, what have you done?" Loomis said nothing for several seconds. Then he walked back inside and told his team to begin wrapping up. He did not apologize to Barbara. He did not order her zip ties removed immediately. He did not instruct agents to return the judicial case files. Instead, he stepped outside again, pulled out his personal cell phone, and made a second call off Bodycam. No record exists of who he called or what was said. When he returned to the kitchen, he addressed Nwankwo with the flat tone of a man still trying to control a situation that had already left his hands. The investigation is ongoing. Seized materials will be reviewed and returned if appropriate. Nwankwo was already standing, his briefcase open, a legal pad filled with notes. He looked directly at Loomis, his voice steady and precise. You have just raided a federal judge's home on fabricated evidence, seized constitutionally protected judicial files, and terrorized her children. This is not going to be reviewed. This is going to be investigated, but not by you. At approximately 10 a.m., more than 4 hours after the raid began, an agent finally cut the zip ties from Barbara Okwosa Adeyemi's wrists. The plastic had left deep red grooves in her skin. She did not rub them. She stood, walked to the hallway, and asked for her children. Namdi was brought to her first. The 11-year-old crossed the kitchen at a run and wrapped both arms around her waist so tightly she had to brace herself against the counter. He did not let go for nearly 20 minutes. He did not speak. Rosalind came next, led by an agent she refused to look at. She sat down in a kitchen chair, folded her hands in her lap, and stared at the wall. She said nothing. Her eyes were dry and distant in a way that unsettled Nwankwo more than the tears had. The house looked like it had been torn apart by people who did not care what they broke. Furniture was overturned, drawers had been pulled out and emptied onto floors. Closets stood open with clothes dragged from hangers. Her late husband's study, the room she had kept exactly as he left it, had been ransacked. His books pulled from shelves, his desk drawers dumped. In the upstairs hallway, a framed photograph of her parents' wedding lay face down on the carpet. The glass cracked in a long diagonal line. Barbara walked through every room with Nwankwo beside her, documenting the damage with her phone. She did not cry again. Her voice was flat, precise, cataloging each violation like evidence. They took the kids' laptops. They took my case files. They took the letters my father wrote to my mother. By 11 a.m., Nwankwo was on the phone with the chief judge of the D.C. District Court. By noon, the judiciary's administrative office had been formally notified. By 2 p.m., a written complaint had been filed with the Department of Justice, Office of the Inspector General. By evening, 3 United States senators had been quietly briefed by senior judicial officials. The machinery of accountability had begun to move. But inside the house, Namdi was still holding on to his mother, and Rosalind had not said a word. On the morning of March 2, 2026, Bill Tavares sent his footage to a reporter at a local television station. He had not slept. By midday, the story was everywhere. Every major outlet ran some version of the same headline, and each one landed harder than the last. Homeland Security raids federal judge's home, calls her Iranian spy. Black federal judge zip-tied in own home during pre-dawn raid. HSI agents seized active judicial case files during raid on judge's home. Legal analysts went on air within hours, calling it one of the most egregious violations of judicial independence in modern American history. Former federal prosecutors described the seizure of active case files as an act that strikes at the foundation of the separation of powers. Civil rights organizations issued formal statements demanding a full federal investigation. The Federal Judges Association, a body that almost never comments publicly on individual cases, released a rare and sharply worded condemnation. Social media erupted. The Bodycam footage had not yet been released, but Tavares' exterior video was viewed over 4 million times by nightfall. One frame in particular spread faster than any other. Agents in tactical gear carrying labeled evidence boxes down the front steps of the house while, in a second-floor window above them, the face of a child was barely visible behind a curtain, mouth open, crying. That image became the defining picture of the case. By late afternoon, HSI leadership moved. Senior Agent Craig Loomis and Supervisory Special Agent Donna Kessler were both placed on administrative leave pending internal review. Magistrate Judge Howard Pruitt, who had signed the warrant after 9 minutes and 0 questions, issued no public comment. But by evening, sources close to the court confirmed he had retained personal legal counsel. The silence from Pruitt's chambers said more than any statement could have. On the afternoon of March 2nd, Obiora Nwankwo filed an emergency motion to unseal and challenge the search warrant affidavit that had authorized the raid on Barbara Okuosa Adeyemi's home. A federal judge in the neighboring District of Maryland granted the motion within hours, citing extraordinary circumstances involving the constitutional integrity of the judiciary. By evening, the affidavit was public, and when legal analysts began reading it on live television, what they found was not an intelligence case. It was a fabrication held together by distortion and audacity. The Iranian connections that Loomis had cited as the foundation of his case amounted to a single trip to Tehran in 1994 by Barbara's late father, a biology professor who had attended an academic medical conference and had been dead for a decade. The covert financial channels were routine wire transfers, fully documented and tax reported, sent to elderly relatives in Lagos. The clandestine meetings at The Hague referred to Barbara's attendance at a judicial conference organized by the United States State Department itself. She had been formally invited by the federal government to attend the very event Loomis described as evidence of espionage. There was no confidential informant named anywhere in the document, no corroborating intelligence from the CIA, the NSA, or the FBI, no interagency coordination of any kind. Loomis had built the entire case from open-source records, deliberate mischaracterizations of lawful activity, and his own unsubstantiated assertions presented as fact. Former federal prosecutors appeared on every major network, calling it the thinnest affidavit they had ever seen approved by a sitting magistrate. Questions mounted quickly about Magistrate Judge Howard Pruitt's 9-minute review, whether he had read the document at all, and whether the rubber stamping of a warrant this baseless represented its own form of institutional failure. By the evening of March 2nd, the legal filings were done, the phone calls to senators had been made, and the news cycle was burning with her name. But inside the house in Silver Spring, none of that reached the 2 children trying to sleep in bedrooms that no longer felt safe. Rosalind had spoken fewer than a dozen words since the morning of the raid. She flinched at sudden sounds, the creak of a door, a car engine outside, the neighbor's dog barking. She asked her mother once, quietly, standing in the hallway before bed, "Are they going to come back?" Barbara told her no, but the question hung in the air because Barbara could not promise that with the certainty her daughter needed. Nnamdi had not slept through the night since March 1st. He had begun wetting the bed again, something he had not done since he was 5 years old. On the night of March 2nd, as Barbara tucked him in, he looked up at her with an expression no 11-year-old should carry and asked, "Did you do something bad, Mama?" Barbara held his face in both hands and told him no. She told him she had done nothing wrong. She told him the people who came to their house had made a mistake. But she could see in his eyes that the answer did not land the way it needed to, because the damage was not about information. It was about what had been taken from him. The belief that his home was a place where nothing could hurt him. After both children were in bed, Barbara closed her bedroom door, sat on the edge of the mattress, and called her sister in Baltimore. Her voice, the same voice that had stayed level through zip ties and interrogation and federal motions, finally broke. "They didn't just raid my house. They stole my children's sense of safety. I don't know how to give it back." A child psychologist who would later evaluate both Rosaline and Nnamdi would describe their symptoms as consistent with acute trauma disorder. The report would note hypervigilance, sleep disruption, emotional withdrawal, and regressive behavior. It would note that these symptoms had been caused not by an accident or a natural disaster, but by agents of their own government, in their own home, in the dark. As of March 3rd, 2026, the machinery of accountability is turning, but no one has yet been held to account. Multiple investigations are now open simultaneously, each pulling at a different thread of the same catastrophic failure. The Department of Homeland Security Office of Inspector General has launched a formal probe into Senior Agent Craig Loomis, Agent Bryce Dillingham, Supervisory Special Agent Donna Kessler, and the full approval chain that authorized the warrant. The Department of Justice Inspector General is conducting a separate investigation into whether the raid constituted an obstruction of judicial function, a question with constitutional implications that reach far beyond a single case. The Judicial Conference of the United States, the policy-making body for the entire federal court system, has convened an emergency session focused specifically on the seizure of active case files from a sitting judge's home. In a statement released this morning, the conference called the seizure a direct assault on the independence of the federal judiciary. The FBI has opened a parallel criminal inquiry into whether Loomis fabricated evidence in the affidavit, which, if proven, would constitute a federal crime carrying significant prison time. Congressional leaders from both parties have demanded hearings. Letters have been sent to the DHS Secretary, the Attorney General, and the Director of National Intelligence, requesting full briefings. Loomis, through his attorney, has released a single statement claiming he acted in good faith based on available intelligence. Kessler has not commented publicly. Dillingham has reportedly retained separate counsel and requested to cooperate with investigators. Magistrate Judge Howard Pruitt has been quietly recused from all pending cases on his docket. And the seized judicial files, the active case documents taken from Barbara Okuwosa Adeyemi's home office, have not yet been returned. Among her colleagues on the federal bench, Barbara Okuwosa Adeyemi is described the same way by nearly everyone who knows her work. Principled, thorough, fearless when it matters. Over 4 years on the bench, she built a record that earned respect from prosecutors and defense attorneys alike. But it was her rulings on government surveillance that drew the most attention. She had written multiple opinions pushing back on overreach by federal agencies, including the Department of Homeland Security. She had questioned the scope of warrantless data collection. She had demanded specificity in affidavits where other judges accepted vague language. 2 of her Fourth Amendment opinions had been cited by appellate courts as models of constitutional reasoning. She had, in short, done exactly what a federal judge is supposed to do. She held power accountable. And now, legal commentators across the country are asking the question openly. Was this really an intelligence failure? Or was it retaliation? Was a black woman who dared to check federal authority made into a target by the very apparatus she had held to account? No direct evidence of retaliation has emerged, not yet. But the investigation is ongoing, and the coincidence has not gone unnoticed by anyone paying attention. Barbara herself has not spoken publicly. She has not appeared on camera. She has not given interviews. Through Obira Nwankwo, she released a single written statement on the evening of March 2nd. It read, "I swore an oath to uphold the Constitution of the United States. On March 1st, agents of the federal government broke into my home and violated that Constitution in front of my children. I intend to ensure that every person responsible is held accountable. Not for my sake, but because if they can do this to a federal judge, they can do it to anyone." This story is not finished. As of March 3rd, 2026, no one has been charged. No one has been fired. No one has been arrested. The judicial case files seized from Barbara Okuwosa Adeyemi's home remain in government custody, active federal proceedings handled by agents who had no legal right to touch them. Barbara's children are still not sleeping through the night. Rosaline still flinches when a door closes too hard. Namdi still crawls into his mother's bed before dawn, afraid of the dark in a way he never was before. Craig Loomis is on paid administrative leave, collecting a federal salary from his home, while the woman whose door he broke down tries to explain to an 11-year-old why the people who are supposed to protect them were the ones who came with guns. The investigations are open. The Inspector General is reviewing. The FBI is examining. Congress is demanding answers. But the process is slow, deliberate, and offers no comfort to a family still living in a house with a front door that no longer locks properly and a living room window still boarded up with plywood where a flashbang grenade came through before sunrise on a Saturday morning. The public is watching. The legal community is watching. Civil rights organizations are watching. And somewhere in a quiet house in Silver Spring, Maryland, a federal judge is sitting on the edge of her daughter's bed, smoothing her hair, telling her it is safe to close her eyes, knowing that she cannot yet prove that is true. This is not a story with a resolution. Not yet. But the cameras were rolling. The Bodycam footage exists. The neighbor's video exists. The affidavit is public. The evidence is preserved. And the people responsible have names, badges, and records that are now under a level of scrutiny they never imagined possible. Because when they planned this raid, when they drafted that warrant, when they threw that grenade and broke down that door, they assumed the woman in pajamas on the hallway floor was no one who mattered. They were wrong. This case was disturbing, but the one on the right ends in a way no one expects.
My name is Vivian Achebe-Laurent. I am a United States District Judge for the Eastern District of Virginia. You need to verify that immediately.
Oh, I know exactly what name is on this address. And I don't care what title you think protects you. We have intelligence tying this house to suspicious foreign activity.
At 6:12 a.m. on Sunday, March 1st, 2026, the smell of pancakes filled a narrow Alexandria townhouse 3 blocks from the Potomac. Judge Vivian Achebe-Laurent stood at the stove in a cotton robe, flipping batter while her 7-year-old son Solomon sat cross-legged on the couch watching cartoons with the volume too loud. Upstairs, her 11-year-old daughter Nadia was already dressed for church, arguing through the bathroom door that Solomon had taken her hairbrush again. It was the kind of morning that didn't make the news. Quiet, ordinary, warm. Vivian was 44 years old, Harvard Law, top of her class. She had spent 6 years as a federal prosecutor at the Department of Justice before being nominated to the U.S. District Court for the Eastern District of Virginia. Senate confirmed 4 years ago with bipartisan support. She carried an active caseload that included 2 national security matters and a high-profile civil rights case that had drawn attention from Washington and beyond. She was disciplined, private, and careful with every word she spoke on and off the bench. That morning, her church dress hung on the back of her bedroom door. Solomon's clip-on tie sat on the kitchen counter next to a sippy cup he swore he didn't use anymore. Nadia's Bible study notebook was open on the dining table, a colored pencil still wedged in the spine. Vivian had no idea that in less than 30 minutes, the front door of her home would be blown off its hinges, that federal agents in tactical gear would pour into her kitchen, that her son would be dragged off that couch and put face down on the floor, that her daughter would be grabbed by the arm at the top of those stairs, and that everything about this morning, every quiet, ordinary detail, would become evidence in one of the most devastating federal civil rights cases in modern American history. 6 weeks earlier, on a Tuesday afternoon in January, FBI counterintelligence analyst Craig Stenner sat at his desk inside the J. Edgar Hoover building in Washington, scrolling through the Bureau's online tip portal. Stenner was 36, competent enough on paper, but known among colleagues as someone who chased volume over accuracy. He flagged more tips than anyone in his unit. Most went nowhere. He didn't seem to mind. At 2:17 p.m., a submission caught his eye. It alleged that a woman living at 814 Braddock Lane in Alexandria, Virginia, had been making wire transfers to financial entities with suspected ties to Iranian intelligence. The tip included a name, Vivian Achebe-Laurent, a partial physical description listed as black female, early 40s, and a claim that she had been photographed at a restaurant in Georgetown with a known Iranian diplomatic attaché. There was no supporting documentation, no account numbers, no surveillance imagery, no name attached to the person submitting the tip. It had come through an anonymous portal entry routed through a burner email. Stenner flagged it and forwarded it to his supervisor, Special Agent in Charge Brent Kirkwood. Kirkwood was 52, a career bureau man with a reputation for aggressive case development and a deep interest in counterintelligence headlines. He read the tip once, asked no follow-up questions, and approved it for preliminary investigation the same afternoon. No one ran Vivian's name through the federal judiciary employee database. No one checked whether she held a government position. No one cross-referenced her address with any law enforcement or intelligence personnel records. The tip was vague, uncorroborated, and anonymous. It should have been flagged for further vetting at minimum, or dismissed outright. Instead, Kirkwood told his team to move fast. He called it a potential high-value lead. And from that moment on, every decision that followed was built on a foundation that no one in the Bureau had bothered to verify. Over the next 6 weeks, every safeguard that should have caught the mistake failed. Not one of them held. Stenner built the case file the way he built most of his cases. Fast, surface level, and with just enough material to look thorough without actually being thorough. He pulled Vivian's financial records through a parallel channel typically reserved for FISA-adjacent national security requests, a move that bypassed the more rigorous internal review process. What he found should have told him everything he needed to know. Vivian had made recurring donations to a legal aid nonprofit that served immigrant communities, including clients from the Middle East. The transactions were modest, documented, and tax-deductible. Stenner flagged them as suspect wire transfers to entities with foreign ties. He never contacted the nonprofit, never checked its tax status, never noted that it had been operating legally in Virginia for over a decade. Then came the photograph. During a 2024 legal conference in Washington hosted by the American Bar Association, Vivian had posed in a group photo with more than a dozen attendees. One of them happened to be a mid-level Iranian diplomatic attaché who had been invited to a panel on international law. Vivian hadn't spoken to him individually. She didn't know his name. But the photo made it into the file, captioned as evidence of a potential clandestine relationship. A junior analyst in the unit, Priya Venkatesh, 29, raised concerns in a written memo. She pointed out that the financial records didn't support the conclusion being drawn, that the tip was anonymous and uncorroborated, and that no one had verified the subject's employment or government affiliation. Kirkwood read the memo, called her into his office, and told her to stay in her lane. 2 days later, her objections were removed from the case file entirely. Kirkwood told his team this could be a big one, and no one left in the room was willing to tell him he was wrong. The warrant application landed on the desk of a federal magistrate judge in the Eastern District of Virginia on February 26, 2026. The affidavit was 12 pages long and built almost entirely on 3 pillars: the anonymous tip, the mischaracterized financial records, and the conference photograph. Each piece of evidence had been framed to suggest something it did not actually prove. The charitable donations became suspect international transfers. The group photo became a documented meeting with a foreign intelligence-linked operative. The anonymous tip became a credible source with knowledge of the subject's activities. What the affidavit did not include was any mention of Vivian Achebe-Laurent's occupation. It did not state that she was a sitting United States District Judge. It did not note her prior service as a Department of Justice prosecutor. It did not reference her Senate confirmation, her security clearances, or her active national security caseload. The magistrate judge reviewed the affidavit, asked no clarifying questions, and signed the warrant that same afternoon. Kirkwood moved immediately. He assembled a full tactical entry team of 14 agents, body armor, sidearms drawn, flashbang grenades authorized. The raid was scheduled for 6:45 a.m. on Sunday, March 1st, a time specifically chosen because the subject would be home and, in Kirkwood's words, less likely to have outside support present. No one on the team suggested a less invasive approach. No one proposed a simple knock on the door. No one recommended calling her attorney or serving the warrant through the court. 14 agents, full tactical gear, drawn weapons, a battering ram, and a federal judge making pancakes for her children on the other side of the door. The operation was approved without a single voice asking whether any of it was proportionate. At 6:44 a.m., 1 minute ahead of schedule, the battering ram hit the front door of 814 Braddock Lane. The lock shattered on the first strike. The door frame splintered inward, sending wood and metal across the entryway floor. 2 flashbang grenades followed, one into the living room, one toward the kitchen. The concussive blasts shook the walls. Solomon, who had been lying on the couch watching cartoons with a blanket pulled to his chin, screamed. An agent in full tactical gear reached him in 3 steps, pulled him off the cushions by his arm, and forced him face down onto the hardwood floor. He was 7 years old. In the kitchen, Vivian spun toward the sound just as 2 agents came through the doorway. One grabbed her by the shoulder and drove her sideways into the counter. Her face struck the granite edge. The impact split the skin above her left eye. Blood ran down her cheek before she hit the floor. She was forced onto her stomach, arms wrenched behind her back, wrists locked into handcuffs. She could hear Solomon crying from the living room. She could hear boots on the stairs. "I am a federal judge," she said. Her voice was loud and clear despite the blood and the pressure on her spine. The agent kneeling on her back didn't pause. "Sure you are," he said. Upstairs, Nadia heard the explosions and the screaming and came running down the staircase in her church dress, shoes untied, eyes wide. An agent intercepted her halfway down, grabbed her by the upper arm, and brought her to the floor beside her brother. She was 11. She landed on her knees and then her chest, her face pressed to the same hardwood where Solomon lay sobbing. Both children were now on the ground, surrounded by armed men in black helmets, in their own home, on a Sunday morning.
Vivian lay on the kitchen tile with her cheek against the cold floor, blood pooling beneath the cut above her eye, her wrists locked behind her back at an angle that sent pain through both shoulders. Her breathing was controlled. Her voice, when she spoke again, was steady and precise. "My name is Vivian Achebe Laurent. I am a United States District Judge for the Eastern District of Virginia. My judicial credentials and identification are in my study. Second door on the left, top drawer. You are making a catastrophic mistake." The lead entry agent, Supervisory Special Agent Russ Pennington, 45, stood over her. For the first time since the breach, he did not move immediately. Something in her tone, in the specificity of her words, in the calm that no ordinary person under duress could manufacture, made him pause. He keyed his radio. "Command, the subject is claiming to be a federal judge, requesting guidance." The response came from Kirkwood, sitting in a black SUV parked 2 houses down, monitoring the operation on a tablet. "Continue the search. She can sort it out downtown." Pennington hesitated for half a second longer, then gave the order. Agents moved through every room. Books were pulled off shelves and thrown to the floor. Drawers were dumped. Closets were emptied. They seized both of Vivian's laptops, her personal phone, an external hard drive containing case research, her children's school tablets, and 3 family photo albums. In the living room, Solomon had stopped crying and gone silent, his small body trembling, a dark stain spreading across the front of his pajama pants. He had wet himself. Beside him, Nadia lay with her eyes open and her chest heaving in short, shallow gasps, unable to slow her breathing, unable to speak. A federal judge's children, face down on their own floor, surrounded by agents who still had not verified who their mother was. And in the SUV outside, Kirkwood checked his watch and typed a message to headquarters. Raid executed. Subject secured. Proceeding with evidence collection.
The noise carried. In a neighborhood like this one, where the houses sat close and the streets stayed quiet on Sunday mornings, the sound of a door being broken open and flashbang grenades detonating was impossible to miss. Frank Oberlin was the first one outside. He was 68, retired Army colonel, lived in the townhouse directly next door, and had known Vivian for 3 years. He had watched her carry groceries inside on weeknights, had waved to her children when they played on the front steps, had attended the same neighborhood association meetings where she sat quietly in the back row, always polite, always composed. When he stepped onto his porch and saw the black SUVs, the tactical gear, and the agents moving in and out of Vivian's front door, he walked straight to the perimeter tape. "That's a federal judge's home," he told the agent guarding the line. "Her name is Vivian Achebe Laurent. She sits on the Eastern District bench." The agent didn't blink. "Sir, step back or you'll be detained." Oberlin didn't move. "You're making a mistake. I'm telling you who lives in that house. Step back. Now." Oberlin pulled out his phone and began recording. Across the street, Terrence and Simone Osei had come to their front window when the first blast shook the block. Terrence grabbed his phone and started filming from the doorway. The footage was shaky, but clear. Agents in full tactical gear, a broken front door, and then, at 7:03 a.m., the image that would later be seen by millions. Vivian Achebe Laurent, in a cotton robe and church slippers,
blood visible on the left side of her face, hands cuffed behind her back, being walked down her own front steps by two agents while a neighbor's child watched from a second-floor window across the street.
Within minutes, the footage was in a neighborhood group chat. Within an hour, a local journalist had it in her inbox. Within 2 hours, it had already been shared more times than anyone in that neighborhood could have predicted. And not a single agent on the scene had yet confirmed who they had just raided. At the FBI's Washington field office, Vivian was placed in an interrogation room on the 3rd floor. The handcuffs stayed on. The cut above her eye had not been treated. Blood had dried in a thin line down her left cheek and along her jaw. She sat upright in a metal chair, still wearing her robe and slippers, and said nothing. She did not ask for water. She did not ask where her children were. She asked for one thing. "I want my attorney. I will not answer questions without counsel present. I am a sitting United States District Judge. You can verify this in less than 60 seconds. The two agents in the room exchanged a glance. One left. The other stayed by the door, arms folded, silent. Vivienne sat still. For nearly 2 hours, no one verified her identity. No one ran her name through the federal judiciary database. No one contacted the Eastern District Clerk's office, which operated a 24-hour duty line specifically for emergencies involving judicial personnel. At 9:14 a.m., more than 2 hours after the raid, a junior agent who had not been part of the entry team typed Vivienne's full name into the federal court's personnel system. The result appeared in under 4 seconds. Achebe Laurent, Vivienne R. Title: United States District Judge. Court: Eastern District of Virginia. Status: active. Appointed by the President. Confirmed by the Senate. The agent stared at the screen, pushed back from his desk, and walked quickly down the hall. He found Kirkwood in a briefing room reviewing evidence logs. "Sir, the subject is a federal judge." Kirkwood looked up. "What?" "She's a sitting U.S. District Judge. Eastern District of Virginia. Senate confirmed. Active bench." The room went quiet. Every agent in it understood in the same instant what had just happened and what was about to come. Kirkwood set down the file he was holding. His face lost its color. Down the hall, in the interrogation room, Vivienne sat exactly as she had for the last 2 hours. Bleeding. Calm. Waiting. And somewhere on the 3rd floor, someone finally thought to ask the question that should have been asked 6 weeks ago. Did anyone check who she actually is? While Vivienne sat in that interrogation room for 2 hours, waiting for someone to confirm what she had told them from the moment they broke down her door, her children were in a separate room on a different floor of the same building. Solomon and Nadia had been transported in the back of an unmarked federal vehicle. No car seats, no seatbelts fitted for a child Solomon's size. No explanation of where they were going or why. Solomon had not spoken since the agents put him on the floor of his own living room. He sat in a plastic chair with his knees pulled to his chest, still in the pajamas he had wet during the raid, the fabric now cold against his skin. No one had offered to change him. No one had offered him clothes or a blanket or food. He was 7. Nadia sat beside him, rigid, staring at the wall across the room. She had stopped hyperventilating in the vehicle, but had not spoken a full sentence since being pulled to the ground on the staircase. When a victim's advocate was finally brought in, more than 90 minutes after the children arrived, she found them sitting in silence in a room with no windows, no toys, no crayons, nothing that acknowledged they were children. The advocate, a woman in her 50s who had worked with the Bureau for over a decade, later told investigators it was one of the worst things she had seen in her career. A child psychologist brought in that afternoon conducted preliminary evaluations on both children. Solomon exhibited signs of acute stress response, including trembling, selective mutism, and a flinch reaction triggered by any sudden movement or loud sound. Nadia presented with emotional shutdown, flat affect, and what the psychologist described as hypervigilant stillness, a trauma response more commonly associated with children in war zones. Vivienne was not allowed to see her children until 9:47 a.m., nearly 3 full hours after they had been separated. When she finally entered the room, still in handcuffs that had only just been removed, Solomon looked up at her and said one word: "Mama." It was the first thing he had said in over 3 hours. By 10 a.m. on March 1st, the machinery of institutional panic had begun to move. The first call went from the FBI's Washington field office to the chief judge of the Eastern District of Virginia. The conversation lasted less than 2 minutes. The chief judge's response, according to sources briefed on the call, was a single question, repeated 3 times. "You did what?" By 10:15, the administrative office of the U.S. courts had been notified. By 10:30, 2 United States senators with oversight of the Judiciary Committee had received calls from their staff flagging an incident involving a sitting federal judge. By 10:45, the FBI Director's Office was alerted through an internal channels memo marked urgent, a classification rarely used outside of active threat scenarios. Kirkwood was pulled from the case before noon. He was told to return to the field office and not to contact any member of the investigative team. Stenner, the analyst who had flagged the original tip and built the case file without ever verifying the subject's identity, was placed on administrative leave effective immediately. His access to classified systems was suspended. Supervisory Special Agent Russ Pennington, who had led the tactical entry, was reassigned to administrative duties pending review. The DOJ Office of Professional Responsibility opened an emergency inquiry before the end of the day. Behind closed doors at the Hoover Building, the damage assessment was already underway. A deputy director convened an emergency meeting with senior leadership from counterintelligence, legal counsel, and the inspection division. The question he asked the room, according to 2 officials present, was direct. How did we raid the home of a sitting federal judge, put her face down on her kitchen floor, hold her children in a windowless room for 3 hours, and not one person in this building knew who she was? No one answered immediately. The silence in that room carried the weight of what everyone already understood. This had not been a failure of technology or access. The databases existed. The information was there. No one had looked because no one had thought to look. A black woman with an African surname living in a nice neighborhood had matched someone's idea of a threat, and from that point forward, every system designed to prevent exactly this kind of catastrophe had been bypassed, ignored, or overridden. And now the entire Bureau was going to answer for it. The neighbor footage reached social media before the FBI had even confirmed Vivian's identity. Terrence Osei's video was 43 seconds long. Shaky, slightly overexposed in the early morning light, but unmistakable. A black woman in a cotton robe and church slippers, blood on her face, hands cuffed behind her back, being walked down the steps of her own home by 2 agents in tactical gear. Behind her, through the broken front door, the audio captured a child screaming. The video hit a neighborhood group chat at 7:11 a.m. By 7:40, a local journalist had it. By 9 o'clock, a Washington reporter confirmed through court records that the woman was a sitting United States District Judge. The story detonated. Every major outlet ran some version of the same headline: FBI raids home of black federal judge. The footage played on loop across cable news and social media. Legal analysts called it unprecedented. The National Bar Association issued a statement calling the raid one of the most egregious violations of judicial independence and civil rights in modern American history. The NAACP demanded a full independent investigation. By evening, 14 sitting federal judges had signed a rare joint statement expressing profound concern over the treatment of their colleague. 2 members of Congress called for emergency oversight hearings. A constitutional law professor at Georgetown told a reporter she had never seen anything like it in 30 years of studying federal law enforcement. And in a windowless room at the Washington field office, the 2 children at the center of it all still had not been given a change of clothes. In the days that followed, the institutional rot beneath the raid began to surface. Investigative journalists filed records requests on Kirkwood's counterintelligence unit. What emerged was a pattern stretching back nearly a decade. Of 41 investigations opened by his team over 8 years, 29 had targeted individuals who were Black, Middle Eastern, or South Asian. More than half were initiated on anonymous or thinly sourced tips. Fewer than a third produced anything actionable. None led to a prosecution. Kirkwood's unit had operated under national security classification that shielded it from routine oversight. Internal review mechanisms deferred to his judgment. The result was a team with minimal accountability and a supervisor who treated aggression as ambition. Priya Venkatesh, the junior analyst who had flagged concerns 6 weeks before the raid, cooperated with the DOJ Office of Professional Responsibility. Her written memo questioning the case's evidentiary basis had been removed from the file before the warrant application reached the magistrate. Kirkwood had told her to stay in her lane. She had kept a personal copy. She turned it over to investigators on March 2nd. Separately, digital forensics teams began tracing the anonymous tip. The submission had come through a burner email created the same day, routed through a VPN. But metadata recovered from the portal's backend pointed to someone familiar with federal court procedures. Investigators began quietly exploring a possibility that would transform the case entirely: that the tip had been fabricated by someone connected to one of Vivian's active rulings. If confirmed, it would mean the FBI hadn't just failed to vet the evidence, it had been weaponized. As of March 2, 2026, Vivienne Achebe-Laurent has not spoken publicly. Not a single word to the press, no interviews, no statements on camera. Her attorney, former federal prosecutor Camille St. Pierre, issued a brief written statement on her behalf that afternoon. It confirmed that a federal civil rights lawsuit was being prepared. It requested the immediate preservation of all body camera footage, tactical communications, surveillance recordings, internal emails, and case files related to the investigation. It stated that both children were being evaluated by a trauma specialist and that the family was requesting privacy while they began to process what had happened less than 24 hours earlier. The statement was 4 paragraphs long. It said everything it needed to say and nothing more. Legal observers noted that Vivian's silence was not absence, it was strategy. She was a sitting federal judge who understood that every word she spoke publicly would be scrutinized, dissected, and potentially weaponized to paint her as emotional, politically motivated, or unfit for the bench. Her restraint was not weakness. It was the discipline of a woman who had spent her career inside the system and understood exactly how to dismantle its failures from within. Behind the scenes, her legal team had already contacted the DOJ Inspector General, the Judicial Council, and 2 congressional offices with jurisdiction over both the judiciary and federal law enforcement. The machinery was beginning to move, but Vivian had not yet shown her hand, and anyone who knew her understood that when she did, it would not be emotional. It would be precise. As of this moment, nothing is resolved. Kirkwood has been suspended from duty pending investigation. Stenner has retained a private attorney. Supervisory Special Agent Pennington has been reassigned. The magistrate judge who signed the warrant is under review by the Judicial Council for failure to scrutinize the affidavit. The FBI has issued a single, carefully worded statement acknowledging what it called procedural shortcomings in the investigation. It has not apologized. Congress has called for oversight hearings. 2 Senate committees have requested full briefings from the Bureau's director. Vivian's lawsuit, filed in the District of Columbia, names the FBI, Kirkwood, Stenner, Pennington, and 12 unnamed agents. It alleges violations of the Fourth Amendment, racial profiling, excessive force, false imprisonment, and intentional infliction of emotional distress. Nadia and Solomon have been added as plaintiffs. Their claims include trauma, unlawful detention of minors, and denial of basic care while in federal custody. No settlement has been offered. No disciplinary action beyond suspension has been finalized. No criminal charges have been filed against any agent involved. The investigation into the origin of the anonymous tip is ongoing, with digital forensics still tracing the submission through layered VPN routing. If the tip is confirmed to have come from a litigant connected to one of Vivian's cases, the scope of the scandal will expand from negligence into something far more deliberate. But as of today, none of that has been confirmed. None of it has been denied. The front door of 814 Braddock Lane is still broken. The blood has been cleaned from the kitchen counter. Solomon still flinches at loud sounds. Nadia still has not spoken a full sentence to anyone outside her family. And the woman who sat bleeding on her own kitchen floor in handcuffs is still on the bench, still hearing cases, still waiting for the system she serves to answer for what it did. This case was brutal, but the case on the right spirals completely out of control.
You can't just walk in here demanding things like you own the place.
I'm asking to see my children.
Your daughter has marks on her body and you expect us to just ignore it? Families like yours always have an excuse.
What exactly do you mean by that?
I mean, we've seen this before. Defensive, confrontational, acting.
At 11:47 a.m., inside the front office of Maplewood Elementary School, a white principal stood with her back to the hallway, phone pressed to her ear, and said calmly, "Yes, I need an emergency removal. The children are in danger." Two CPS workers were already walking through the front doors, lanyards swinging, clipboards in hand. The black woman standing 6 feet away, watching this unfold, was not who any of them thought she was. Her name was Nadine Coulter. She was a sitting federal judge on the United States District Court, Eastern District, appointed by the President, confirmed by the Senate, and responsible for presiding over the very type of civil rights case that was now playing out in real time against her own family. Her children, Elijah, 10, and Amara, 7, were sitting in a locked classroom down the hall. Amara had been crying for 20 minutes. Elijah had asked 3 times to call his mother. Both requests were denied. Principal Janet Driscoll had made her decision the moment she saw a bruise on a little black girl's knee. She never consulted the school nurse. She never called the mother. She called CPS and requested emergency removal, using words like imminent danger and signs of physical abuse on multiple children. The school's security cameras were recording everything, every hallway angle, every office entrance, every frame of what was about to become one of the most explosive civil rights cases in the state's history. Driscoll had no idea what she had just set in motion. Before we continue, comment where in the world you're watching from, and make sure to subscribe because what happens next will leave you speechless. Janet Driscoll had been an educator for 18 years, the last 9 as principal of Maplewood Elementary in the affluent, predominantly white suburb of Lake Ridge. On paper, she was a model administrator, involved, organized, and fiercely protective of what she called the culture of this school. In practice, that protectiveness had a pattern. Over the past 6 years, Driscoll had filed 14 CPS referrals against families at her school. 13 of those families were Black or Hispanic. Not a single referral resulted in a substantiated finding of abuse or neglect. Every case was closed. Every family was cleared. And every time, Driscoll moved on to the next one without consequence. Parents had tried to push back. 3 families filed formal complaints with the school board, describing a principal who scrutinized their children more closely, questioned their home lives more aggressively, and treated normal childhood incidents as evidence of dysfunction. The complaints were reviewed internally and quietly dismissed. Driscoll had connections that insulated her. Her husband, Gary Driscoll, sat on the Lake Ridge City Council. Her sister-in-law, Rita Driscoll, worked as a caseworker in the county CPS office. Between the school board, city hall, and child services, Driscoll operated inside a network that had never once held her accountable. She believed she was the gatekeeper of her community, that her judgment about which families belonged and which didn't was not just valid, but necessary. In an email sent to a colleague 2 years earlier, she had written, "Some families just don't belong in a school like this. It's not about race, it's about standards." That email would later be entered into evidence. But on this Wednesday morning, none of that history mattered to Driscoll. She had found what she believed was her next case. A bruise on a black child's knee, and she was already making the call. Nadine Coulter's path to the federal bench began in the Raymond Rouse housing projects in West Baltimore, where she shared a 2-bedroom apartment with her mother and 3 siblings. Her mother worked double shifts as a hospital custodian and kept a rule in the house that was never negotiable: homework before anything. Nadine earned a full academic scholarship to Howard University, graduated summa cum laude, and was accepted to Yale Law School, where she finished top of her class. She clerked for a Supreme Court justice, spent 6 years as a federal prosecutor specializing in civil rights cases, and at 39 was appointed to the United States District Court for the Eastern District, making her one of the youngest black female federal judges in American history. Now 43, she presided over civil rights and constitutional law cases. She had ruled on police misconduct, housing discrimination, and unlawful government overreach. Her opinions were cited in law reviews. Her reputation on the bench was precise, fair, and unmovable. Her husband, Derek Coulter, was a trauma surgeon at the city's largest hospital. 2 years ago, they moved to the Lake Ridge district specifically for the school ratings. Elijah, their son, was gifted and quiet, reading 2 grade levels ahead. Amara, their daughter, was social and artistic, the kind of child who made friends on the first day and drew pictures for her teachers. Both were model students, no behavioral issues, no academic concerns. Nadine volunteered at school events, attended every parent-teacher conference, and donated to the annual fundraiser. Despite all of this, from the very first week, she felt the resistance. Driscoll's greetings were colder to her than to other parents. Her children's behavior was scrutinized more closely. Minor incidents that were laughed off for white students were flagged and documented for hers. At one conference, Driscoll asked Nadine about her home environment 3 separate times. Nadine noticed. She always noticed. She just never imagined how far it would go. That Wednesday morning started like any other. Nadine pulled into the Maplewood Elementary drop-off lane at 7:45 a.m., kissed both children goodbye, and watched them walk through the front doors. Amara wore a navy skirt and a yellow top, her backpack bouncing with each step. On her left knee was a small bruise, greenish-purple around the edges, from falling off her bicycle in the driveway 2 days earlier. Derek had cleaned it, put a bandage on it, and by Monday morning, Amara had forgotten about it entirely. A teacher noticed the bruise during morning circle and, following school protocol, reported it to the principal's office. Protocol required documentation and, if warranted, a call to the parent. Driscoll skipped the call. Instead, she pulled Amara out of class and brought her to the principal's office alone. No parent notification, no school counselor present, no nurse consulted. For nearly 20 minutes, Driscoll questioned a 7-year-old girl behind a closed door. The questions were leading, repetitive, and designed to produce a specific answer. Does mommy or daddy ever hurt you? Do they hit you when you're bad? Are you scared at home? Has anyone told you not to tell? Amara said no each time. She said it clearly. She said it repeatedly. And each time, Driscoll pressed harder. The hallway security camera captured Amara being led into the office with a confused expression and Driscoll closing the door behind them. 20 minutes later, it captured Amara leaving in tears. Driscoll then had Elijah pulled from his 4th grade classroom. Same office, same closed door, same questions. Elijah, more composed than his sister but visibly uncomfortable, answered no to every question and then asked, "Can you call my mom?" Driscoll looked at him and said, "That's not necessary right now." She had already decided what she was going to do, and calling the mother was never part of her plan. At 10:15 a.m., with both children back in their classrooms, still shaken from the interrogation, Driscoll sat in her office and picked up the phone. She did not call Nadine Coulter. She did not walk down the hall to consult the school nurse, Karen Whitley, who would later confirm under oath that the bruise on Amara's knee was entirely consistent with a minor fall, and that no one from the principal's office ever asked her to examine it. She did not consult the school counselor. She did not review Amara's or Elijah's files, which contained no behavioral flags, no prior concerns, and no history of anything other than 2 well-adjusted children excelling in their classes. Instead, Driscoll called the county CPS hotline and reported suspected child abuse. The language she used was deliberate. She described imminent danger and signs of physical abuse on multiple children. She called the parents uncooperative and possibly violent, a characterization based entirely on a brief exchange 2 weeks earlier, when Nadine had questioned why Amara had been moved to a different reading group without notice. That single conversation, a mother asking a reasonable question, became Driscoll's justification for the word aggressive in a government report. Then Driscoll made a second call. This one was to her sister-in-law, Rita Driscoll, a caseworker in the county CPS office. Text messages recovered during the investigation would later show the exchange. Janet wrote, "I need you on this one personally. The mother is difficult, very aggressive. You know the type." Rita responded within minutes. "I'll take care of it. These ones always think they're above the rules." Rita agreed to handle the case directly. No conflict of interest was disclosed. No supervisor was informed. The referral was flagged for emergency response, and 2 caseworkers were dispatched to the school before lunch. Nadine was on the bench when her personal phone vibrated in her chambers at 11:22 a.m. She ignored it. It vibrated again, then a third time. During the next recess, she checked and found a voicemail from Ms. Alicia Grant, Elijah's teacher. The message was brief, her voice low and careful. "Mrs. Coulter, I think you need to come to the school. Something is happening with your children. I can't say more right now, but please come." Nadine didn't call back. She informed her clerk, stood up from the bench mid-session, and drove to Maplewood Elementary still wearing her professional attire. She arrived at 11:40 a.m. The front office felt wrong immediately. The receptionist, who normally greeted her warmly, avoided eye contact. Another staff member turned and walked into the back hallway when she entered. Nadine said, "I'm here to pick up Elijah and Amara Coulter." The receptionist stared at her screen. "If you could just have a seat, someone will be with you shortly." Nadine did not sit. A moment later, Driscoll emerged from the hallway. Her expression was composed, rehearsed. "Mrs. Coulter, your children are being evaluated right now. You can't see them at this time." Nadine's voice was steady. "I'm their mother. Bring me my children." Driscoll folded her hands. "Ma'am, I've contacted the appropriate authorities. It's out of my hands now." "What authorities?" Driscoll paused, just slightly. "Child Protective Services. We have concerns about marks on your daughter. We have a duty to report." Nadine's expression hardened. "She fell off her bicycle on Saturday. I have photos. My husband cleaned the scrape himself. He's a surgeon." Driscoll shook her head slowly, her voice dropping into something almost patronizing. "That's what they all say." The words hung in the air, and at that exact moment, through the glass doors behind Nadine, 2 CPS workers walked into the building. The 2 CPS workers came through the front doors with the practiced efficiency of people who had done this many times before. Rita Driscoll walked in front, lanyard swinging, clipboard already open. Behind her was Tom Wilder, a junior caseworker in his late 20s who had been on the job for less than a year. Rita did not introduce herself by her full name. She did not disclose that the principal who made the referral was her sister-in-law. She looked at Nadine the way she might look at a case file, not a person. "We're here to conduct an emergency assessment regarding your children, Elijah and Amara Coulter. Based on the referral we've received, there are concerns about physical abuse. The children may need to be placed in temporary protective custody pending evaluation." Nadine's hands trembled at her sides, but her voice did not break. "You are not taking my children. I want to see the report. I want to know the specific allegations." Rita shook her head. "I'm not able to share the details of an ongoing investigation at this time." She opened her clipboard. "I'll need to ask you some questions. Do you or your husband use physical discipline in the home? Are there firearms in the residence? Has either parent struggled with substance use?" Nadine answered each question calmly, directly, and without hesitation. Then she said, "I know my rights. You cannot remove my children without a court order, unless there is immediate, verifiable danger. There is no danger. My daughter has a bruise from a bicycle fall. No one in this building even consulted the school nurse." Rita's expression didn't change. "We'll make that determination, ma'am." Behind her, Tom Wilder shifted his weight. He glanced at Nadine, then at the hallway where the children's classrooms were. He leaned toward Rita and whispered, "This doesn't seem right. There's nothing here." Rita didn't turn her head. She simply looked at him with an expression that ended the conversation before it started. Wilder stepped back and said nothing more. Rita looked at Nadine and delivered the words as though reading from a script.
We'll be taking the children for a 72-hour evaluation at a designated facility. You'll be contacted with the details. Nadine's voice was immediate. Absolutely not. You have no court order. You have no evidence. You are not removing my children from this school. Driscoll, who had been watching from the hallway, reached for the phone on the front desk and dialed the school resource officer. Dale, I need you in the front office. We have a situation. Officer Dale Mounier arrived within 2 minutes. He was 44, white, broad-shouldered, and carried himself with the kind of authority that expected compliance, not conversation. He had 3 excessive force complaints in his file over the past 5 years, all dismissed internally. He stepped into the office and positioned himself directly behind Nadine. Rita gestured toward the hallway. We need the children escorted to our vehicle. Nadine turned and stood between Mounier and the corridor. Her back was straight, her feet planted. You will not touch my children. Mounier exhaled slowly. Ma'am, don't make this harder than it has to be. Through the glass walls of the front office, parents arriving for early pickup began to slow down. A woman stopped mid-step on the sidewalk, staring. A man in a parked car lowered his window. Phones came out. A black father named James Whitfield pushed through the front doors and stepped inside. What's going on here? Why are you doing this to her? Mounier pointed toward the exit. Sir, this doesn't involve you. Step outside. Whitfield didn't move. I'm not leaving. I'm watching. In the hallway behind Driscoll, teachers had gathered near their classroom doors. One of them, Miss Alicia Grant, the same teacher who had called Nadine, walked toward the office. Her voice was quiet but steady. Those children are fine. I see them every single day. This is wrong. Driscoll turned sharply. Miss Grant, return to your classroom, now. Grant held her gaze for a moment, then stepped back. But she did not stop watching. No one did. The security cameras above them recorded every frame. Mounier reached for Nadine's arm. His fingers were inches from her sleeve when she stepped back, not in panic, but with the controlled precision of someone who understood exactly what was happening and exactly what came next. She reached into her jacket, pulled out a leather credential case, and held it up at eye level. My name is Judge Nadine Coulter. I sit on the United States District Court, Eastern District. I preside over civil rights and constitutional law cases, including cases exactly like what is happening in this room right now. The room went silent. Not quiet, silent. Rita's face drained of color. Her clipboard lowered to her side. Driscoll, who had been standing near the hallway with her arms crossed, froze. Her mouth opened slightly, but nothing came out. Mounier's hand dropped to his side as though the air itself had pushed it down. Nadine held the credential steady, her voice cutting through the stillness with surgical control. You have fabricated an emergency to remove 2 healthy, well-loved children from their mother based on a bicycle bruise. You have interrogated my 7-year-old daughter behind a closed door for 20 minutes without my knowledge or consent. You have pulled my son from his classroom and questioned him without a parent, guardian, or counselor present. You have used language in a government referral that you know to be false. And you have attempted to use a family connection inside this CPS office to fast-track an unlawful removal. She turned and looked directly at Rita. I know who you are. I know your maiden name is Driscoll. I know the principal of this school is your sister-in-law. And I will be requesting a full conflict of interest investigation before the day is over. Tom Wilder took a visible step away from Rita. His clipboard hung at his side. He stared at the floor. Driscoll sat down slowly in the nearest chair, her face slack. James Whitfield, still standing near the door, exhaled audibly. Through the glass, 2 parents had their phones raised, recording. No one in the room moved. No one spoke. Because every person standing in that office understood that the ground beneath them had just shifted in a way none of them could undo. Nadine did not wait for anyone in that room to find their voice. She stepped into the hallway, pulled out her phone, and made 2 calls. The first was to her husband, Derek. She spoke in short, precise sentences. I'm at the school. They tried to take the children. CPS was called on a fabricated report. I need you here.
The second call was to her judicial chambers. Her law clerk, Daniel Reeves, answered on the first ring.
Nadine's instructions were specific.
Contact the county CPS director immediately, then call the state inspector general's office, then the U.S. Attorney's Office Civil Rights Division. I want all three notified within the hour. Reeves didn't ask questions. He started dialing before she hung up. Within 30 minutes, the calls had landed. The county CPS director reached Rita Driscoll on her cell phone. The conversation was brief. You are to stand down immediately. Do not touch those children. Do not speak to the mother. A supervisor is on the way. Do not leave that building. Rita said nothing. She sat down in the front office and placed her clipboard on the desk, face down. At the same time, the school district superintendent received 4 separate calls from parents who had witnessed the scene through the glass office walls. One parent had already posted a video to social media. A local news producer received a tip from someone in the parking lot and dispatched a crew. By 2 p.m., Nadine was in the locked classroom with her children. Amara ran to her, tears streaming, and pressed her face against her mother's chest. The lady kept asking if you hurt me, Mommy. I told her no. She kept asking. Elijah stood by the wall, arms folded, jaw tight for a 10-year-old. I told them you didn't do anything. They didn't listen. They didn't care. Nadine held them both. She kept her voice even. She told them everything was going to be okay. She walked them through the hallway, past the silent office staff, past Driscoll's closed door, and out into the parking lot. She buckled them into the car, closed the door, sat in the driver's seat, and for the first time that day, broke down completely. The investigation moved faster than anyone at Maplewood Elementary expected. Within 48 hours, federal and state investigators had secured the school's security footage, every frame preserved and cataloged. The cameras told the story Driscoll had hoped no one would see. Amara being led down the hallway into the principal's office, her small face confused, the door closing behind her. 20 minutes later, the same door opening and Amara emerging in tears. Then Elijah, pulled from class, escorted into the same office, the same closed door. The footage showed Driscoll making 2 phone calls afterward, one to CPS and one to a personal number that records confirmed belonged to Rita Driscoll. Investigators subpoenaed the text messages between them. The exchange was devastating. Janet had written, I need you to handle this one personally. The mother is difficult, very aggressive. You know the type. Rita's reply came 4 minutes later. I'll take care of it. These ones always think they're above the rules. Those messages would later be read aloud in a courtroom. Driscoll's email history revealed the broader pattern. Over 6 years, she had filed 14 CPS referrals. 13 involved Black or Hispanic families. Not one was substantiated. Every case was closed without findings. The school nurse, Karen Whitley, filed a sworn statement confirming that the bruise on Amara's knee was entirely consistent with a minor fall, and that Driscoll never consulted her before making the report. Ms. Alicia Grant and 3 other teachers provided statements confirming the Coulter children were happy, well-adjusted, and showed no signs of abuse or neglect. 2 of those teachers went further. They revealed that Driscoll had pressured them on multiple occasions to document minor behavioral incidents involving minority students, things like talking out of turn or forgetting homework, while identical behavior from white students was ignored entirely. The pattern was not subtle. It was systematic, and now it was on the record. The U.S. Attorney's Office did not wait for the internal reviews to run their course. Within 2 weeks of the incident, a federal civil rights investigation was formally opened. The charges came down 1 month later. Janet Driscoll was charged with conspiracy to deprive civil rights under 18 U.S.C. Section 241, filing a false report to a government agency, and abuse of authority in connection with her role in public education. The indictment detailed not only the Coulter case, but referenced the pattern of racially targeted referrals spanning 6 years. Rita Driscoll was charged with abuse of authority, conflict of interest, and conspiracy. She was terminated from the county CPS office the same day the charges were announced. Her supervisor issued a statement confirming that Rita had never disclosed her familial relationship with the referring principal, a direct violation of agency ethics policy. Officer Dale Mounier was placed on unpaid leave pending a full investigation into his role at the school and the reopening of 3 prior excessive force complaints that had been previously dismissed. The Lake Ridge School Board convened an emergency session. Driscoll was terminated by unanimous vote. Board members who had previously dismissed complaints against her sat in silence as the security footage played on a screen in the closed session. 2 of them would later face public calls for their own resignations. Gary Driscoll, Janet's husband and sitting city council member, resigned within the week. Investigators had uncovered evidence that he had used his position to intervene with the school board on 2 prior occasions when complaints about his wife were escalating. His resignation letter cited personal reasons. No one believed it. Tom Wilder, the junior CPS caseworker who had whispered, "This doesn't seem right," in the school office that day, cooperated fully with federal investigators. He was not charged. His testimony detailed how Rita had directed him to bypass standard intake protocols, skip the supervisory review, and move directly to emergency removal without sufficient evidence. He said he had objected quietly, and she had shut him down. His cooperation would become a critical piece of the prosecution's case. The federal trial opened on a Monday morning in a packed courtroom. The gallery was full. Journalists lined the back row. Civil rights attorneys sat behind the prosecution. Families who had been targeted by Driscoll over the years filled the remaining seats, some of them seeing each other for the first time, realizing they were not alone. Prosecutors built their case methodically. First came the security footage from Maplewood Elementary, played on courtroom monitors in unbroken sequence. The jury watched Amara being led down the hallway, her small hand at her side, her face uncertain. They watched the office door close. They watched it stay closed for 20 minutes. When the audio from the interior camera was played, enhanced and transcribed for clarity, the courtroom heard a 7-year-old girl say, "My mommy didn't hurt me," over and over, while an adult voice continued pressing. Several jurors looked away. One wiped her eyes. Then came the text messages. Prosecutors displayed them on screen, one after another. "I need you to handle this one personally. You know the type. These ones always think they're above the rules." Then, the email. "Some families just don't belong in a school like this." Then, the referral history. 14 reports, 13 against families of color, 0 substantiated. Driscoll's defense argued she had acted in good faith, exercising her duty to protect children. The prosecution dismantled it in hours, showing she never consulted the school nurse, never contacted the mother, fabricated language in the CPS report, and coordinated a back-channel removal through a family member. Rita's defense collapsed entirely when her own text messages were read aloud a second time during cross-examination. Her attorney offered no rebuttal. Over 20 families testified about Driscoll's pattern. The jury deliberated for less than a day. Guilty on all counts for both defendants. Driscoll was sentenced to 4 years in federal prison. Rita received 2 years and 6 months. Officer Dale Mounier, tried separately, was fired and permanently decertified based on the investigation into his conduct history and his role in the attempted removal. Judge Nadine Coulter recused herself from the bench for the civil proceedings and retained private attorneys to file suit on behalf of her family. The lawsuit named the Lake Ridge School District, the county CPS office, Janet Driscoll, Rita Driscoll, and Officer Dale Mounier as defendants. The claim cited civil rights violations under federal law, unlawful interrogation of minors without parental consent, intentional infliction of emotional distress, fabrication of a government report, and systemic racial discrimination enabled by institutional negligence. The evidence made the case nearly impossible to defend. Security footage, text messages, email records, referral data, teacher testimony, and the sworn statement of the school nurse formed a record so thorough that settlement negotiations were brief. The case settled for $1.8 million. But the money was not the point. As part of the agreement, the district and county committed to sweeping structural reforms. mandatory parental notification before any child could be questioned by school administrators about suspected abuse, independent oversight of all CPS referrals originating from schools, demographic auditing of referral patterns with public annual reporting, conflict of interest screening for all CPS caseworkers assigned to school-originated cases, mandatory implicit bias training for all school and CPS staff with quarterly assessments. The impact reached beyond the district. The state legislature, citing the Coulter case and floor debate, passed what became known as Coulter's Law, a statute requiring that all CPS emergency removal requests be reviewed and approved by an independent judicial officer before children could be separated from their parents. No more removals based on a single unverified phone call. No more back-channel coordination. No more unchecked power over families who had done nothing wrong. Nadine used a portion of the settlement to establish the Coulter Family Justice Initiative, a legal defense fund providing representation to families of color targeted by false or racially motivated CPS reports. Within its first year, the initiative took on 37 cases across 4 states. 12 resulted in formal findings of misconduct against the reporting parties. Every one of those families had been told, at some point, that the system was working as intended. 6 weeks later, on a bright Monday morning, Nadine Coulter pulled into the drop-off lane of a new school. Elijah sat in the back seat with his backpack between his knees. Amara sat beside him, her hand already reaching for the door handle. They walked in together. Elijah's shoulders were straight. Amara held her mother's hand and looked up at the building with curiosity, not fear. A teacher greeted them at the entrance with a smile. No one stopped them. No one questioned whether they belonged. No one looked at them and saw a problem to be solved. They were children walking into a school, and that was all they needed to be. Back at Maplewood Elementary, a memo circulated to all staff the following week. It was issued by the new interim principal and reviewed by the district's legal office before distribution. At the top of the page was a single still frame pulled from the school's own security footage. It showed a 7-year-old girl in a navy skirt being led down a hallway by an adult hand on her shoulder. The girl's face was turned slightly toward the camera. Her eyes were wet, her mouth was open, mid-sentence. Beneath the image were 6 words. "This is what failure looks like." No names were printed. They didn't need to be. Janet Driscoll was in federal prison. Rita Driscoll was in federal prison. Dale Mounier had lost his badge, his certification, and any future in law enforcement. Gary Driscoll had resigned from the city council. The school board members who had dismissed years of complaints were facing recall campaigns. The system that had protected all of them, that had filed away grievances, buried patterns, and treated Black and Hispanic families as problems rather than people, was forced to change. Not because of outrage alone, not because of public pressure alone, but because of evidence, because of teachers who spoke up, because of a father who refused to leave, because of security cameras that captured what was meant to stay hidden, and because the woman they tried to break happened to be someone the system could not ignore. In an interview months later, Nadine Coulter was asked what she wanted people to take from what happened. She paused, then said, "I had the